legal research. So it could expose you to what legal problems you consider very what they contain in existing laws. But in some cases, you find less of history, and you also even available court briefs. The lawyer will file to argue their case. So, the legal researcher is a basic point. You will need to begin with your responsibilities, your lawful lawyers of lawful. In expediting legal research, you know some basics about the structure of government, the structure of legal system. For example, you'll be in America, practice in the United States, some state, actually a federal state, you consider, and the lawyers would be licensed on state basis. So you consider two precious sources of law: state law, case law, and also the government is functioning on the separation of power principle. So, as I said, Congress and judiciary and executive all are generating the laws in the meaning of legal research. What they consider, for example, president may utilize the executive order to substantiate their constitutional responsibility. We have a limited scope of a ground provisions about the scope, and, for example, appointment power may be enlisted with supplements of internal regulation. Department of Justice may ID check or the security check about the nominee or candidates, the background and the criminal history, for example, financial history, many other personal information would be gathered on through the process. And also, you will have a chance to visit a website, Federal Register. So APA is a very great statute in effect. In fact, we find many democratic principles that the public agencies or executive officers should respect through process of their job duties. For example, they need to make it on public notice in the website of Federal Register, and they get information from stakeholders or interest enterprises or citizens. I favor this. So, and often official and also the APA requires the public agencies or evidence-based decision. So they need to gather evidence. Also, science-based decision is other principle. The government should be scientific, reasonable, but actually the state is kind of incarnation of public goodness. So we rely on the government. It must be credible. What sources of credibility could be verified? Science and many expert support for public policy in actually critical impact on the life of citizens, US citizens, should be considered. So the nature and characteristic of database quite actually important when you conduct legal research. What is that? And structure of legal system is also important. So for the U.S. lawyers, you must have basic awareness about separation of power principle and federalism. So the state, how the state government operates to serve the public goodness. You have a Senate, state Senate, or House, and also governor's office, for example, and a state judiciary. They produce the laws and rules to be applied to their jurisdiction. State of Minnesota, for example, state of Colorado, state of California. And the state government often takes a similar form with a federal government. So they often have a dual unit of the legislature, Senate and House. And governor is kind of a replacement of presidency when our president in the analysis. President is the chief executive officer in the state. And also we have state judiciary to deal with the case of controversy, legal question. And also the state has state constitution, a supreme role in that jurisdiction. Provided if any local federal issue would be presented about that case of controversy. So the normal wisdom about three types of appeal system would be found in your search. State and states, you may navigate the 10 jurisdictions for comparative study of a criminal policy, for example. Why the state is designed in this way. You have model penal code, for example, the reference purpose, so you may compare, and also compare with other states, criminal statute of other states. So, you also have some awareness about the area doctrine, as I mentioned in the previous class. And what we have Congress, executive, judiciary, which is what read through the federal constitution. 3 chapter articles, and actually the main text is composed of 7 articles, which should be called chapter in your normal sensibilities of law. The article is quite long, so pages will be required to cover the main text, and you have trainings or amendments. They add a constitutional amendment. The repeal system is different in ways. So they would repeal by adding new amendment. Not they rephrase the main text. So we can chart the historical wake of a constitutional culture. So the Constitution is quite important and very consequential through your research and legal career in the United States. Since the United States is a federal state, so Constitution plays a pivotal role to provide legitimacy about the jurisdictions. Federal jurisdiction, one subject we will learn in U.S. law school, for example. And a considerable number of cases will involve the constitutional issues. The sole process for the American lawyers are actually often harboring it around constitutions issue, and also many case laws on the subject. So now you have a great benefit from e-context of a access. You may know the word e-government. What is that? Electronic government. So now you can visit the website of United States Supreme Court to consult with the court decision, recent court decisions about the controversy. Private right issue, important national issues about federalism, and what is the meaning from the Commerce Clause, and how do we sustain that from the previous cases. So precedent is as binding power, as you see, it is country of a state decisis doctrine. So they could not, on its face, negate the effect of a precedent. They should devise a way to variegate the rulings to adapt with new challenges. They now affirm precedent on its face. And they also are required to respect the public statute. It is the political expression of the United States constituents, citizens. So they are bound by that public statute. Nonetheless, some lenient judges would find many ways to skillfully handle contradiction or others. So we have new case law theory. So it falls within some esoteric dimension of legal expertise, technicality. And also, you will be an international lawyer who are now enthusiastic with some international mission. Then you research the database, for example, the UN documents about human rights. So a Human Rights Commission is a judicial institution who renders an advisory opinion. How do you see its effect? In fact, it could not work in protection about extreme cases. Actually, you see the atrocity of execution was a quite surprising scene. But the state could only have authority to deliver a death penalty. The power would only be grounded on polity. So we often consider the state norms would be any untainted form. We generally conceive as law. We now are aware of many non-state norms. You may encounter the words Republic of Scotland. that is because we need to have a uniform practice. So the challenge is quite difficult to reach any fast way of a harmonization. Uniformity is hard to achieve in private law initiative. For example, you will know some famous Smith, Prof. Smith, with legal reformer and leader of UNCITRA. He will lead a group of scholars to make a uniform private law. That effort could come to fruit in some dimension, but it is actually very time and expense and on a great work demand. So long time is required, and many expenses would be necessary to support the uniform movement. So, for example, 20 or 15 years will be consumed to reach a consensus. The draft will be open for ratification. And one successful international treaty or covenant would be CIC. What is that? So in a uniform central, resulted from decades of effort in the United Nations. It could be said very successful, actually, which is a fair contrast with Hague Convention. So the official title is CISG, as said, Convention on International Sales of Goods. So its coverage was noted in the official title. So very limited session would be reached, despite the kind of contention and disagreement from global states. So Korea also vetoed